Hello everyone, how are you all doing? Welcome to your next session on Sale of Good Act. In the previous session, we understood sale and agreement to sell. We understood the meaning of it and also the difference between them. Now, in today's class, let's see what we are going to discuss. Today, we are going to discuss the topic of transfer of ownership and risk. This is a critical concept that can influence the rights and obligations of both buyer and seller. Specifically, we'll cover the passing of property, the importance of timing, risk and liability implications, and the rule of nemo dat quod non habet, along with some real life explanations and examples. By the end of this class, you should understand how and when ownership transfers in a transaction, how that affects the risk and liabilities, and the legal principles that apply when someone sells goods they do not own. So let's get started. Moving on to the next slide, let's see rules relating to the passing of property. First, let's talk about what it means for ownership to pass from one party to another. The passing of property refers to transfer of legal title from seller to the buyer. The moment the buyer becomes legal owner of the goods is critical because it impacts when risk and liability also transfer. Ownership passes when the parties intend it to pass, and it is often determined by the terms of the contract. For instance, if contract says ownership passes when buyers pay in full, then even if the goods are delivered earlier, the buyer doesn't become the owner until and unless the payment is complete. Example, imagine a seller and a buyer agreeing on a sale of a car. The seller hands over the car keys and the registration paper to the buyer. In this case, even if the buyer hasn't paid the full price yet, ownership may have already passed to the buyer because the intent of transfer was clear. However, if the contract clearly states that ownership passes only after the full payment, then the seller retains the ownership until that condition is fulfilled. Does that make sense to you? The key is intent, and it can be explicitly stated or inferred from the circumstances and nature of the transaction. So if you see here, passing of the property refers to transfer of ownership from seller to the buyer. This transfer signifies that the buyer now holds the legal title to the property and has the right to possess it or use it. Key principles are governed by Sales of Good Act. In case if it is an international contract, relevant local legislation. Ownership typically passes based on the intention of the parties involved, which can be explicitly stated in the contract, as we have already discussed. Here, there is an example which says a seller named Raj sells a car to the buyer named Priya for whatever amount. The moment Raj hands over the keys and registration paper to Priya, ownership is transferred, even if she has not paid the amount. The intent to transfer ownership can be inferred from the action, such as delivery, unless the contract says otherwise. Okay. Now that everyone has understood rules relating to the passing of property, let's move on to the next slide. Timing of transfer of ownership. The timing of ownership transfer is crucial as it dictates the rights and obligations of both parties, particularly regarding liability for loss or damage. The key points here are ownership may pass at different times based on contract terms. If a seller retains a right to reclaim the goods until payment is complete, ownership may not pass immediately. Let's understand this with an example. A buyer orders a custom built laptop from a manufacturer. Ownership of the laptop passes when the manufacturer completes the laptop, I mean, manufactures the laptop and hands it over to the buyer. If the laptop is damaged during manufacturing, the manufacturer bears the risk because the ownership has not transferred and at that time it was damaged. Timing impacts who's responsible for loss or damage. Taking this scenario, imagine if after delivery anything happens to the product, it is the buyer's responsibility and risk. In that case, unless there is a warranty or guarantee, in that case, the seller will be definitely responsible. But if there is no guarantee or warranty, again, guarantee warranty is part of your contractual term, right? So in this case, if any damage has happened after the manufacturing is done and the delivery is done, it will be the buyer's responsibility. In case if the damage is done during the manufacturing process or it does not meet the need that, because it's a custom built laptop, right? So it does, if it does not meet the need of the buyer, it will be the seller's responsibility. Hoping you have understood the timing of transfer and its importance, let's move on to the next slide. Impact on risk and liability. Risk of loss. Now, this brings us to the impact of ownership transfer on risk and liability. As I mentioned earlier, the general rule is that risk follows ownership. Once the buyer becomes the owner, they bear the risk of any loss or any damage to the goods, unless the contract specifies otherwise. So let's understand this with a easier example. Imagine a buyer purchases a shipment of perishable goods like fruits. If the ownership transfers when the goods are loaded onto the truck and they spoil during the transport, the buyer is responsible for the loss. Even though he haven't or they haven't physically received the good yet. If the ownership has yet not passed, let's say the contract states that the ownership passes only upon delivery, then the seller would still be responsible for any spoilage during the transit. This is why it is critical for both parties to clearly define when the ownership and the risk transfers. It can save a lot of trouble and legal disputes, future legal disputes that could cause or arise due to the misunderstanding between the parties. As we have discussed the impact of risk and liability in detail, let's move on and see what we have next. Sale by non-owners. The rule of nemo dat quod not habet. So, what is this rule? Now, let's talk about this rule of nemo dat quod not habet. It means no one can give what they don't have. The principle ensures that only the rightful owner of the goods can transfer the ownership. If someone who does not own the goods sell them, the buyer does not acquire a valid ownership unless an exception does apply in this scenario. This rule is there to protect the true owner of the goods. But there are some exceptions which can make things a little more complex. For instance, under the principle of estoppel, if the true owner allows a third party to believe that the seller has the right to sell the goods, the buyer can obtain a valid title. Similarly, in cases where goods are sold by authorized dealers or auctioneers, even if the dealer doesn't own the goods, the buyer can get a valid title because the dealer is authorized to sell them. It's also the case in an agent principal relationship where the principal gives the authority to the agent to sell a property, lease a property, or any type of goods which they own. So that is generally the case when it comes to a relationship of agent and principal. I'll give you an example here of sale of stolen goods. So let's look at an example. Suppose a thief named Vikram steals a valuable painting and sell it to unsuspecting buyer who has no idea like that these goods are stolen. So there is a girl named Meera who buys this painting for let's say 10 lakh rupees. Even though Meera paid for the painting and she does not have any knowledge of the goods being stolen, she does not acquire a legal ownership because at the first place the situation makes this contract a void contract as Vikram did not have the right to sell the painting. The true owner of the painting can reclaim it from Meera. This is a classic example of Nemo that fool in action. Vikram could not transfer what he did not own. Okay, I'll explain it to you with another example to understand the exception. Now let's consider a different scenario. An authorized electronics dealer named Rohan sells a smartphone to Anjali for 30,000 rupees. Rohan may not own the smartphone right out, but he's authorized by the manufacturer to sell it, right? In this case, Anjali acquires a valid ownership of the smartphone. Even if the manufacturer later tries to claim the phone, Anjali has a legal standing to keep it because dealer was authorized to sell on behalf of the manufacturer. Now, if you clearly see these two examples highlight the difference between unauthorized and authorized sale. In Vikram's case, the sale was unauthorized, illegal, and the buyer loses out. But in Rohan's case, the sale is legitimate and it protects the buyer. What do you think other scenarios might apply where these exceptions might apply? As I've already told you, in cases of principal and agent, where the principal gives the authority to agent to sell the goods. For example, you are running a shop, you hire a person as a salesperson in the shop to sell the products. Though the salesperson whom you have hired is not the owner of the goods the salesperson is selling, but still you as a owner has given an authority to the salesperson to sell the goods. And that is why here the transaction between the salesperson and any customer who comes to the shop will be legitimate. Okay. I hope everyone has understood the principle clearly and the exception that is attached to this principle. And this is how we define sale by non-owners, right? Here we have an example of a person named Sam sells a bike that he does not own. As it is under a loan with the bank, the buyer, Arjun, has no legal claim to the bike because Sam could not legally transfer ownership. If the bank claims the bike, Arjun will lose it without compensation. Exception scenario is an authorized dealer sells a new car on behalf of the manufacturer, even though the dealer does not own the car. They have the authority to sell it. The buyer, Neha, obtains valid ownership as the dealer is authorized to act on behalf of the manufacturer. So this is about the rule of nemo dat pot non-habet. The one no one can give what they do not have. So to understand the concept in detail, let's move on to the next slide. Here are the case study and examples which we have already discussed in detail where Vikram sells a stolen painting. to Meera, and then the authorized dealer transaction between Rohan and Anjali, and how these two example explain the application of principle and exception in applying the principle. So here we have come to end of this module where we have understood what are the rules relating to transfer and what are the risks and liabilities associated with transfer of ownership. To wrap up things, today we have covered a lot of ground. We talked about transfer of ownership and how timing plays a big role in determining who bears the risk and liability of the goods. We also discussed the principle of nemo dat, which protects the rights of true owners. And we went through a couple of examples that highlighted how these legal principles work in real life with their exceptions. Remember, understanding when ownership passes can protect you from significant losses in commercial transactions. And always be cautious when you're drafting this type of contract, sale of goods contract for your client. You have to clearly mention the timing of transfer of the ownership because this could lead to future and disputes and confusions between the parties and the contract will fail. So here we have come to the end of today's class. I hope everyone has understood what we have explained. If you have any further doubts, anything, any queries regarding the content, please reach out to me for the question. Until then, I'll see you in the next class. Speak legal, speak weightage. Bye-bye.